Do you swear that you will tell the truth, the whole truth, and nothing but the truth?
Yes.
So, thank you. You were sworn. Thank you for being here today. Do you have any opening statement?
Well, maybe I should give you some background on my involvement in the project that leads us here today. I first got involved in matters relating to the Harrisburg Resource Recovery Facility in 1989. The mayor asked me to become involved in a matter that was ongoing at the time. The city had put out an RFP to sell the Resource Recovery Facility, and that was prior to my involvement. The RFP was issued, but out of that process, there was a firm that was selected, and negotiations were underway with that firm, and the mayor asked me to become involved in the negotiations, and that's how it started. Ultimately, the negotiations to sell the facility broke down, and the city elected to continue to operate and own the facility until it was sold to the authority in 1993. The structure of that ownership by the authority and operation by the city remained in place until Covanta was hired to run the plant in 2007. So I was intimately involved in all matters relating to the incinerator from 1989 until 2004, when I left city employment to start my own business, and I was engaged as a consultant by the authority in 2004 until 2007. So I was kind of surprised this morning to hear testimony that the forensic audit seemed incomplete because they were unable to speak to the parties who had involvement in this project. I'm not saying it as that it is a badge of honor, but there's no single human being alive that knows more about the project than I do. The forensic audit authors contacted me for documents, which I produced, and I never heard another word from them. I was not interviewed, asked, or consulted about any of the things in the audit. And I can tell you from what I read and what I heard today that there are serious statements, misinformation, and a lot of innuendo in that report that potentially could mislead you in what you're trying to do. I'd be happy to address any of the issues in the forensic audit to the best of my ability. I'm here voluntarily. I've never been represented by an attorney in any of these matters, and I'm not now.
Thank you. I appreciate you being here, and I'll note for the record that when we've asked you for information, you've been very quick to give it to us, and we appreciate it. Senator Blake.
Thank you, Ms. Lispi. I'm on a very short clock here, so I was going to say that you are probably the one who knows the most, given your explanation of your experience with it going back so far and leading all the way up to today. I'm probably going to be repeating some of the same questions that I've already offered out to some of our other testifiers. There are issues here that relate to professional representations about the performance of the facility. Again, I'll allow you to maybe bring some clarity to some of the things in the forensic audit that you may object to, innuendo, to using your word. But part of what has been stated in the forensic audit is that the projections on the cash flow don't support, that the amount of debt that was being incurred. What's your take from the inside on the fact that there were no challenges to those projections?
There was a lot said about that and self-liquidating debt, and there was an inference that there was some misrepresentation on the part of the ability of the facility to generate the necessary revenues. I heard that, if I'm not misstating it. Yesterday, I went back to the 2003 bond documents. I pulled out a section of the bond documents, which was a public document that all the investors saw, all of the public bodies saw. In it, there is a financial pro forma that was prepared by Barlow with input from the city and other professionals that estimated the revenues, expenses, and debt service that would be related to the retrofit project. When I looked at that pro forma yesterday, you heard the mayor accurately say that in 2010, I believe it was, the projected revenue from the facility was $25 million total revenues. That would be tipping fees, electric, all other sources of revenue. And as the mayor pointed out, it turns out today that it is actually producing more than that in revenues. The unfortunate part, as has been discussed before, is that the project costs more than it was estimated at the time. The operating expenses that I looked at in the pro forma, they look to be fairly accurate with what is going on today of what it costs to operate the facility. So it's not that difficult to answer some of the follow-up questions that occurred, which was how much of this debt should be self-liquidating? Because you can take the total revenues from the facility, subtract the operating expenses, and you're left with an amount that's available to service debt. You can look at what the cost of that debt is and figure out fairly readily how much of the debt can be supported by revenues. And because of the cost overruns of the project, I would definitely think that there would be stranded debt. In other words, there would be debt that could not be serviced solely by revenues from the facility alone. But based on the revenues that are being generated now, my rough idea of what the expenses are, because I have no information from the authority on what they're paying for operating costs now, but I would think that a significant portion of the outstanding debt could be paid for by revenues. If $225 million was on paper able to be supported by revenues from that facility, and those projections of revenues and expenses being fairly accurate, I can't think that it would be too far-fetched to say that around $200 or $225 million of that debt could be self-liquidating or supported by revenues.
I understand, and I appreciate your testimony, and I also appreciate the clarity with which you can deliver it without having to refer to anything. So that tells me a little bit about what you know. But I have to ask you this. There was a pivot point, right? The issue of the amount, it's going up $1 million a month right now. It's $340 million. At least that's what I've read in the news, and I think that vote increases. There was a pivot point as to whether the issue that explains perhaps the position that the city finds itself and that the authority finds itself is time. It wasn't done on time, it wasn't done on budget, and they essentially, if I can use the expression of the previous testifier, doubled down to try to catch up, get it done right, make it, even to the mayor's words, a performing asset. But there had to be some judgment at some point, I believe, in the public interest about whether or not that risk was appropriate. And I wonder if you can explain in retrospect whether or not, as you look back, that double down decision was in the public interest.
You're asking me, in 2003, when the original bonds were issued, what was the thinking at the time on whether to proceed with the project, right?
Mm-hmm.
Okay. Contrary to some of the statements in the report and other things that I've read and heard, there was an exhaustive process to look at alternatives to rebuilding this project. We had actually tried to do the project in the 90s and come up with the answer that the project wasn't financially feasible at the time. We looked at other technologies. The mayor mentioned gasification. That was one of them. There were many different ones. We actually had a full feasibility study done on gasification. We looked at the option of shutting the plant down, just walking away and cutting our losses. We looked at recycling, combinations of the above, rebuilding the facility, increasing recycling. So at the end of the day, the only project, the only idea that appeared to be technically, environmentally, and financially feasible was retrofitting the project. Had we decided to shut down in 2003, testimony was given today that we were under a consent order from EPA that after June 18th of 2003, we were done. If we had not proceeded with the retrofit of the facility, and the city of Harrisburg at that time, without any revenues to be generated from the facility would have been responsible for paying the existing debt, which at that time, when it was all rolled up, the various bond issues in 2003, is about $100 million. So that we had a very reasonable expectation from what we had seen over the 3-year period that we had worked with Barlow to get to the point of developing a project, that that facility would support operating expenses, the old debt, and the new debt. And that's the pro forma that I looked at today. So there were all kinds of ideas that were explored to try to address the situation that we were in. That was the only one that met the criteria. So the decision to move forward was based on that information that we had at the time.
Understood. Last question, Ms. Lispi, and I have to excuse myself, so my apologies for that, but the performance bond I brought up a number of times with other testifiers. Speak to your experience on it, if you can. Most of the people we've talked to, including the mayor and others, indicate that it was only after the fact. Mr. Clark mentioned, it wasn't really a question that was raised at the authority level. Can you speak to your memory about that issue?
I was involved. I was still a city employee at the time that the negotiations began with Barlow to finalize the contract, which was ultimately signed in April of 2004. So for most of that period of time, in fact, probably all of it, I was a city employee and sat on the authority side of the table as the city representative. There were counsel for the authority, their solicitor. There were counsel for Barlow, Barlow's representatives, the authority's executive director. So the authority and the city were well represented, at the table. We negotiated many different aspects of the contract, including the performance bond. The initial position was the city wanted a performance bond from Barlow to cover 100% of the cost of the construction of the project. So what happened was that Barlow went looking for a surety to do that. They found out that the technology, they were the engineer, and the patent holder. The project relied on their patented technology to perform. To get a surety to bond the technology that it was all going to work together was financially impractical. The cost would have been so enormous, and I don't remember what the figure was, but Barlow indicated that it would make the project infeasible. So we began to explore an alternative security package. Many people have said there were no bonds for the project. That's not true. In fact, all of the actual construction work that was done at the project, people who physically were putting the project together, they all had bonds. And contrary to what was stated in the report, the bonds were in favor of the authority. Some of the bonds were also in favor of Barlow, but they were two parties. I'm sorry, excuse me.
That's a specific, contrary to what was in the report. That,
yes.
There was only one bond, it was for the benefit of Barlow, and that none were for the benefit of the
What I specifically remember when Chinbro, who was a subcontractor to Barlow, who had posted a bond for their construction, it was about $18.5 million. When the project was behind schedule, Barlow and Chinbro got into a dispute, and a settlement was finally reached with Chinbro, and one of the aspects of the settlement was the authority had to agree to release Chinbro from the bond. So that's why I remember that it was also in favor of the authority. In addition to that, the authority withheld a 20% retainage on every bill that Barlow submitted. It's customary in public works projects for retention to be held, but the standard number is 10%. So we negotiated a double figure of 20%, so the authority had more security than they would have under a 10%. You hold the retainage until you're sure that the contractor has faithfully performed, and you can release the retainage at the time when you're satisfied that that's occurred. So that was another form of security that was added. And also, there were separate projects that were outside of the Barlow patented technology area, which was the furnace, boiler, and air pollution control systems. We had a turbine generator project, the smokestack repair. There were a whole bunch of related projects that were outside of the technology area, and those were bid separately by the authority and contracted directly between the contractor and the authority, and all had bonds. So while there's a grain of truth to everything, and it's obvious after what happened that the security didn't address the problem.
Thank you, Mr. Chair. I appreciate it. Mr. Chairman, I excuse myself, so thank you.
Senator Fulmer.
Yes, thank you. Since you're the best informed person on this project, what should we be asking that we haven't been asking? What are we missing?
I don't know how you prevent something like this from occurring, absolutely. There's risk in every construction project. There's ways to mitigate the risk and make it less, but it cannot be completely eliminated. Some of the mayor's suggestions I thought were pretty good, that if there was an independent review, but we had independent engineers look at this project beforehand. None of them identified actually what the problem was. In fact, it hasn't even been discussed today what really went wrong. Another factual error in the forensic audit report.
Can I ask you something? Not to interrupt your answer, but you just made a statement that, and repeat it, maybe I heard it wrong. To this day, there was no discussion of what went wrong.
No, I said I haven't heard anyone talk about what really went wrong.
But why was that?
I'm going to apologize in advance because this is going to get technical, okay? But the report says that eventually Covanta came in and took out all of Barlow's equipment that was part of the tech. That's completely false.
Right.
The furnace, the incline grate, the forced air system that is the crux of their patented technology remains in place. What really went wrong was the back end of the facility, where the hot gases escaping from the furnace are cooled and treated to remove dioxin, mercury, and particulate matter. They go through a series of processes, ending up in a bag house which traps the fine particulate matter. Long story short, because of the equipment that was specified by Barlow in the back end of the plant, the ash was not hot and dry as is needed to move it easily from the bag house to the back end of the facility where it's finally disposed of. It was wet, moisture was making it clump and clog the back end of the facility to an extent where it would shut the facility down. When we first saw it light off, it performed beautifully. Shortly thereafter, the problems appeared because of the ash.
Well,
When Covanta came in and looked at what needed to be done, they made many modifications to the back end of the facility to address the ash issue. And those were primarily what was needed to get the facility into operating condition. So the mayor had no idea that you shouldn't use an air heater in combination with this equipment. I didn't. None of the professionals on the project had, even the engineers who looked at it, never identified this weakness in the design. It only became apparent after the plant was actually lit off and tested. It actually tested perfectly when it was first lit off. But then within weeks' time, the ash problem surfaced and the project would not have operated properly had those issues not been addressed as they have been now by Covanta.
So, are we missing anything that we should be asking?
It was an engineering flaw. It wasn't a performance bond issue. You couldn't have gone back to those contractors and said, we want, your bond, because they put in what Barlow told them to put in. So
Okay. My next question is, I'm going to actually repeat a question as I asked Mayor Reed. It seems to be, the common theme is that no one did anything wrong, and if that's true, how did the city, the authority, and the county end up with a huge financial debt for the citizens of Harrisburg to contemplate with at this present time?
Well, the mayor referred to a cascade of events. The cascade began with the problem that I just described to you, which meant that the facility couldn't be completed on time and within budget. And then that required raising additional capital. Raising additional capital to finish the project took time and cost money, and delays, further delays, compounded the problem of the cost overrun. And that cascade is what has led to, the increase in the amount of debt that exists today at the facility.
Well, as was noted earlier, this committee is about trying to get information and try to find any things that maybe we need to do as a legislative body and so forth. And recognizing that hindsight is always 20/20, what, if anything, you would have done differently or recommended be done differently? And again, I know it's always 20/20.
The one thing that I thought of, I kind of knew this question would be asked. The one thing that I look back on, I regret the fact that we didn't terminate Arlo earlier.
Okay. Okay. Hey, as you look back, and tying into that, as you look back, would you say the mistakes that were made were errors of omission or commission?
I think omission.
Omission. Yes. And then finally, what, if anything, do you think the General Assembly should do to avoid such mistakes in the future?
I just don't know how you eliminate risk.
Okay. Thank you. Thank you.
Mr. Lispi, getting back to performance bond, retainage isn't ever considered part of security. I mean, that's standard practice, and it might have been beefed up a little bit, but it's clearly not security. That's interesting. I mean, I'm aware that the folks that put the forensic audit report got the information about who was named on the bonds. That should be an easy thing to check. But the law requires either a performance bond or other security that would be acceptable, and that concoction that was put together was not acceptable under the law. More specifically, though, the bond indenture in that case specifically states that a performance bond for 100% must be provided. So no one must have looked at that bond indenture, I assume. Were you aware of that at the time?
It was looked at. The authority was represented by their solicitor. Their solicitor approved the contract, including the bonding that was put together for the project. Barlow's counsel wrote a memorandum looking at, the issue of the performance bond and how it could be addressed. And those are the things that led to the formation of the package of security that you see in the forensic audit. So those lawyers, and I told you I'm not one, I believed that it was legal, that it met the requirements of the law at the time. Those lawyers representing the company and the authority believed that it was legal, and they signed the agreement. As I recall, the crux of the matter was that construction requires 100% performance and payment bond. The purchase of materials and equipment does not. So a good part of the cost of the project was the purchase of materials and equipment. And I think that's what led to the creation of the performance bond package that you see to meet the requirements of the statute. Are you talking about the bonds or the CIT? The bonds?
About the performance bond, the lack of the performance bond.
I don't think we ever specifically discussed that issue with the mayor because it was all part of the contract negotiations, and when it was presented to the mayor and the authority, The professionals and the lawyers were saying, you know, the contract is here are the major, you know, terms and conditions, this is the cost. We believe that it's all good. So I think that it, at the time, wasn't a detail that anyone thought had to be specifically discussed, that it was, you know, it was part of the contract.
You didn't have any insurance or bonding professionals looking at this? Just a couple of attorneys.
No, there weren't, no.
I'm an insurance guy, and I always
Okay.
ask the attorneys where their insurance license is, and whenever they start to give insurance advice sometimes.
Well, we had insurance on the project, builder's risk. So
Yeah.
there was like
That's different,
a
yeah.
big OSIP wraparound program and all that for, but not to cover, the performance bond, of course, is different.
Right.
Yeah.
What do you know about the special project account? We had some questions about that along the way here.
I don't know anything about it. That account was held by the Harrisburg Authority, and just like all of the other funds that they had, they were under their control. I never approved any invoices. I never made any requisitions to, other than for my own consulting services. That never came out of the special projects fund. It came out of the construction fund. So I remember sitting at meetings where they would, in public, talk about a requisition from the special projects fund, and it would go to the floor and they would approve it. And that's all I know about it. Other than that, I have no specific knowledge of what went on with it.
And perhaps my last question is, and I had asked other testifiers today, when you were at an authority meeting, how did you see things happening? Who was directing things? How did the flow of information come to the board members, and how were decisions made?
There would be a written agenda that everyone could pick up when you came to the meeting, showing what was on the agenda to be voted on that night. The executive director would guide the meeting, bring up the resolution or the action that was before the authority for approval. A discussion might ensue where a professional who had direct knowledge of the issue before the board would speak, and the authority then would vote on the measure in public, and it would either be approved or denied right at the meeting, in the public meeting.
A lot of professionals there for a lot of the financial decisions?
There were always a representative of each of the systems, the water system, the sewer system, the incinerator, and staff from each of those facilities.
I'm talking about
the
financial
professionals
people.
for, if
Bond
there was a
counsel.
financing, there would be bond counsel there, sometimes underwriters. At the behest of the executive director, he would request that a certain person would be there for the meeting because that measure was going to be voted on that they were involved in.
Who do you think the executive director got their direction from?
Who did he take his direction from? He was employed by the authority board. So if he was taking direction from anybody, it would have been the board. Mr. Milley at the time also worked for the city of Harrisburg as the director of the wastewater facility. So he wore two hats.
So you don't think that in some prior testimony, it appeared to me that the city was calling the shots more than the authority members were making independent decisions?
The city obviously had a direct and immediate interest in the outcome of this project, okay? And that's what I'm testifying to here. The city had a lot of input into what was going on with the retrofit project. So I would agree that it was a joint effort going on. I looked on it as a team. We were all trying to get to the same place.
Okay. Well, thank you very much for
You're welcome.
Appreciate it.